that, right? Answer, yes. So you let the storm come, blow its water, rain. These leads in on this crime scene, correct? Answer, yes. That was Detective Porter. That wasn't Sergeant Mattson. That wasn't Officer Rudy. That wasn't Sergeant Gia. That was his decision that he made. The door was wide open. Different people went up and took a look inside. Clearly, a piece of plastic could have easily been put up. All of that with the storm coming. He could have done it, and he didn't. We know that there was evidence outside on the porch. There was a taser, there was a notebook, there was a probe found later, and at least 4 police officers have testified that aphids were found outside. The state would like you to believe that all that stuff wasn't important. The state would like you to believe that it's okay to let a door that leads into a crime scene be wide open and bougainvillea and water come rushing in. And you can look at the photos and you can see all that water pooled in there and wash it out. And that's okay. It's okay to do that and then come in and ask you 12 people to convict somebody of a serious crime or crimes. And let's talk about the aphids or the confetti. I would suggest to you that the state has made a great effort to lead you to believe that that stuff's not important. Hey, there were 2 tasers? Why do we need the confetti that has the identification on them? We all knew there were 2 tasers. Nobody disputes that. Well, that's true. If all this case was about how many tasers were at the scene, I probably would have to agree. But that's not what this case is about. We know 2 people had tasers. What we don't know is where one of the officers was when he was deploying or shooting his taser. Detective Porter did nothing to protect those because apparently he doesn't know what they are. He was asked, now, before we start reading this, I would suggest to you, if you think back about when I was cross-examining, when Detective Porter was testifying, that when he was asked a question by the state, boy, he had an answer in a heartbeat. But when I asked a question, it took a long time. So we're going to have to read a while to get my point across, the one I'm trying to get across. And each taser has a serial number different than each taser, right, to identify them. Answer yes. Yes. And when these blast doors come off and these 2 probes shoot out with their wires attached to them, there's a bunch of confetti that goes out, right? Answer yes. That confetti is known as, in an acronym, as an aphid, A-F-I-D, right? Aphids plural, right? Answer, I don't recognize them as such. Question, isn't that confetti called by Taser aphids because it stands for anti-felony identification? Answer, I'm not aware of that. But you are aware the Taser, when they make the Taser, puts the probes in, the wires in, blast doors on, and about 40 pieces of this confetti that comes out when you fire the gun, right? Answer, no. You're not aware of that? I am not aware of the number of confetti or whatever it is that we're referring to the max. Are you aware, you told us that you're aware of the confetti. Are you aware that the confetti has a serial number that identifies it and links it to the taser from which it is fired? Answer, no. You're not? No, I'm not. Okay. During this entire time that you were there, I'm sorry, let me withdraw that part of the question. Are you aware that the confetti is colored like pink, blues, whites? Answer, no, I'm not. Question. During this entire time, did you have an occasion to seize any of this confetti from inside of the trailer that may have come from one or both of these tasers? Answer, no, I did not. Question. Let me show you what's been marked as 163 in evidence. Aren't those little pieces of confetti on the carpet there next to the tarp the confetti from the taser? Isn't that what we're talking about? Answer, no. That's not confetti? Answer, I don't know what that is. Question, okay. Let me show you 165 right next to this placard. Those two little pink things, sir, aren't those the aphids, the confetti that comes from a person's taser with the serial numbers that identify who fired that taser? And put those pieces of confetti down there next to placards 19? Answer, I do not recognize what those items are. Question, because you don't know what confetti is? Answer, I do not recognize what those items are. Question, because you don't know what confetti is, sir? Mr. Martinez, objection hasn't answered, the court will rule. Answer, I am not familiar with. You have called it confetti, you have called it something else, and I believe you referred to it as something else beyond that. I am not aware of what those items are. Right, Ms. Merritt? Okay. Well, you and I, with Mr. Martinez, had an interview, correct? Answer, yes. And that's been a week or two ago at least, right? Answer, yes. And I asked you about them at that time, right? Answer, yes. And you indicated, okay. And since that time, since I asked you about these aphids and confettis in your interview 2 or 3 weeks ago, you haven't done any research to find out what they were. Answer, no. Now, let me show you Exhibit 165. This is one of several that are in evidence. There's a placard 19, and it's next to a blast door. That's why it's there. Because apparently Detective Porter knew what a blast door was. But right down beside it are these aphids. These pink identification aphids, confetti, that come out of a taser. Now let me draw your attention now to Mr. Porter's answer, Detective Porter's answer concerning taser aphids. Page 26 on his redirect by Mr. Martinez. And with regard to this confetti coming out and seizing it as part of the investigation, who made the decision as to whether or not to seize this confetti? Answer, I did. Question, and why is it that you did not seize the confetti? Answer, it was of no value. Detective Porter didn't know what aphids were. It had nothing to do with whether he thought it was of no value or not, I suggest. That's an excuse that he wants to give you when he's telling you he didn't know something at the crime scene. Was it important that he picked up those two that I just showed you? No, that's not what this is about. Not those 2 or 3 or 4 that were laying on that carpet. That's not what these aphids are all about. Because those aren't that important. Although it's hard to believe in picking up blast doors, everything else from a taser, that you wouldn't pick up a couple of those and just preserve them. But that's not why we're here to discuss this instruction of failing to preserve important evidence. The importance of the aphids is that they were out on the porch. The Detective Porter didn't see any and didn't tell you about any because he didn't know what they were. So he couldn't have known they were there, couldn't have known to seize them. Putting aside that whether he knew they were there or not, that whole porch should have been preserved, everything, so we could see if there was any blood on a Taser, that it didn't get washed off when the storm blew the bougainvillea inside the French door. Putting that aside, there were aphids all over the front porch. My colleague, I think, suggested to you yesterday that 3 or 4 of the police officers who have testified in this case, or Rich Chrisman, threw those aphids out there, picked them up from inside, put them out there. Well, let me back up a minute. This story from the prosecution yesterday about this conspiracy to help Rich Chrisman stage this setting out in the porch. Let's think about that. Putting aside that, why would Sergeant Agia, with 17 or 18 years of being police force, come in and perjure herself about aphids? Why would she do that? Why would Rudy do that? Why would all these people commit perjury over some aphids in the front porch? Putting that aside. All of them came in and told you there were aphids out there on the front porch. They can't all be mistaken. They were all out there. Where exactly? You know, some saw here, some saw there. But they couldn't have come from inside, and there's no evidence they came from inside. And frankly, if they'd have come from inside and they'd have picked him up outside, and he knew enough to pick him up, they'd have had maybe Rich's serial number on him, and boy, then they'd have caught these 4 or 5 officers who were putting their whole lives on the line to help this guy that morning. But wait a minute, how would they know to do that? Because nobody knew. Nobody knew anything when they arrived at the scene except Rich Chrisman and Officer Virgilio. I mean, they said that everything came and everything had happened, and there was this scar put here and this put here. I mean, why would these 4 officers who the state is telling you that staged this scene out on this porch, how would they know how to stage it? Where would they get all this information? Where's the evidence of that? Because that's why we're here. You see, it's their job, not my job, not Rich Chrisman's job, not Mr. Gantz or Ms. Wildman's job. Our job isn't to prove anything. All we have to do is sit and make them prove that Rich Chrisman is guilty beyond a reasonable doubt. Beyond a reasonable doubt. We're not here to guess or suppose or maybe, or it's a 50-50 chance that this was the first shot. It was. I mean, 50-50 chance, that's not reasonable doubt, that's doubt. I mean, you understand, I know by now, that our position is that Officer Virgilio was outside not helping his partner, and he stood outside and fired his taser. And the aphids, as they come out like this, hit the sides of the trailer and fell down out here. And they were here and there, whatever. If we had those aphids, if apparently the only person who wasn't in on the conspiracy, Detective Porter, if he'd have picked some of those up and said to you, I have these, and they have Officer Virgilio's cartridge serial number on it, and I found them right here on the cement, on the porch, then we would know that Officer Virgilio was lying. They would prove it. That's why they put identification numbers on them. But he didn't do that. The government didn't do that in this case. So, let me give the instruction. let's look at this instruction again. If you find the state has failed, has lost, destroyed, or failed to preserve evidence whose contents are quality important to the issues in this case, and the explanation for the loss, destruction, or failure to preserve is inadequate, you may assume that the evidence was unfavorable to the state. This fact may create a reasonable doubt. You know it is important for Rich Chrisman's defense that these things were out there and that they weren't preserved, and had they been, it would have been extremely helpful. And you know the way the crime scene was in general treated. It's difficult to tell what went on. But I suggest that you pay close attention to that and give it serious consideration. A few brief words about Lon Bartel. He told us how all cops in Arizona are trained. Mr. Martinez would refer to him, as he referred to people that we called to present our case under oath, as our witness. That's what he likes to call our side. Well, Lon Bartel is a Phoenix police officer, and he has an occupation on the side where he is an expert witness, holds himself out to be an expert witness. And Lon Bartel told you he was a master in tasers, and that he was aware and was involved in officer training. And there's a thing called ASPOST, and it's like MVD, the Motor Vehicle Department. You and I want to drive a car. The state of Arizona's got a department called MVD, and we got to go pass a test. And if we pass it, I misspoke. Lon Bartel is a Peoria officer, not a Phoenix police officer. Thank you. MVD won't give us a license unless we pass a test. Well, the police, the people who want to have police licensed have a thing called Arizona ASPOST. And to get a license to be a police officer anywhere in the state, Phoenix, Peoria, Surprise, DPS, you've got to pass their test and be certified by ASPOST. And Lon Bartel told you that he was an expert in knowing how officers are trained. Lon Bartel didn't know Rich Chrisman before this. He's not a friend of his. I think he said he'd met him for a brief moment. He came in as an expert to tell you about how police officers are trained in the state of Arizona. He told you and explained to you that they are taught to react. Now, I don't want to say this, but I don't really mean it quite like it sounds. They're told to react, not think. Of course, they're supposed to think. But the theory is you teach somebody to do something so often, that you do it instinctively. I mean, that's how Rich Chrisman was trained. And that's how he was able to go through the force continuum, as Mr. Bartel told you, inside this trailer in 5 minutes with this suspect, because that's how they're trained. They're trained to react. They're trained to talk. Danny, come out and talk to us. Danny, boom, the door's shut, or tried to be shut. Danny, you've got to come out. Your mother's called us. Danny's not. Hands on. Lon Bartel told you how Rich Chrisman and the other officers were trained. And he told you, let me slow down. And I told you in my opening statement that we would have evidence that it's not like TV. Officers are not taught to shoot somebody in the leg, to stop them or arm. As nice as that might be, they're taught just the opposite. And that was important, I suggest to you, because we have these ideas, we watch a lot of television, and in the sense we just think, God, why couldn't he just, just winged him or something? And it kind of logically makes sense. The problem is they're not taught like that. They're taught to shoot center mass, double tap, 2 shots at the center. And that's what they're trained to do. I mean, they go to the firing range and month after month or however it is, and they keep this training over and over. They can't even get out of the academy until they've done it. And this training teaches them to react and not have to think about, well, what should I do? Yeah, let's put 165 on. Lon Bartel told us a lot about tasers, and he told us from the viewpoint of somebody who was a master taser instructor. It seemed like he knew all about it, and I suggest he did. And he told us about these aphids. I talked to you just a little while ago, and he pointed them out. He told us about the blast doors. He told us about the wire. He told us about the probes. And he told us about the importance of them. And there's no reason I suggest that Mr. Bartel should not be believed. He told us also about pepper spray. Now, you'll remember Rich Chrisman told you about pepper spray. And he told you how he was taught. And he was told, and he told you not only was he taught at the academy, but he told you he was later retaught or retrained or went through it again. They changed, I believe, the spray to the stream, or they changed whatever type they were using, because I think there was some testimony about it caught on fire. But whatever it was, Rich Chrisman was trained twice in it, went through the training twice in it. And he told you, Rich Chrisman, that you got to fight through it, because he told you the evidence is that they're taught like that because it is not uncommon when you're standing right in front of a suspect and you OC him, that there's some possibility of it affecting you. The police trainers know that. They know that it's not like a taser. You don't have to be tased to know how to use a taser. They don't shoot them with the taser. We didn't hear anything about that. But with the OC, it's different. And since they know when an officer is going to use it, there's a good chance he's going to be affected about it. What do they teach them to do? They teach them they have to fight through it. They can't run away. Lon Bartel told you about that. Told you what an officer has to do. Can there be any question that Sergio Virgilio choked up a little bit and ran away? There can't be. If you fail at the academy, you fail as a police officer with the OC's training. And if you fail at the crime scene during your duties, you also fail as a police officer. And that's what happened in this case with Officer Joe. Let me take a minute to talk about Luke Haig, or Lucian Haig. Put aside the fact that he thinks the sternum is cartilage and not a bone, even though they call it a breastbone. Put aside that he doesn't think that when a bullet goes through the body, path can be changed or that is affected. Put that aside. I'm going to suggest to you that Mr. Haig, you're going to be told to give each witness and to give an expert the weight, that expert's testimony and opinions, the weight you think it deserves. And I'm sure that Mr. Martinez could pick at a couple things that my experts said that weren't quite right. And I'm sure I could find a couple things with their experts that aren't quite right. But there has to come a point where an expert is so incorrect that there really isn't any reason to give that expert opinion any value. And here is what Luke Haig said when Mr. Martinez was questioning, not me. In your reading of the medical examiner's report, did you find whether or not, did you read whether or not there was any stippling or sooting on the left arm? Answer, I looked for it in photographic form and written form and found none. Exhibit 373. And there is the stippling on Daniel's left arm. Dr. Johnson said it was there. Dr. DeMaio said it was there. Lucian Haig looked for it in the photographs and in the written reports. He said he'd read the autopsy report, and he found none. I suggest you should find his testimony wanting, and that sums up his explanation. Now, Dr. DeMaio. I suggest his qualifications more than qualified him as an expert in forensic pathology. He was a medical doctor, he was a medical examiner in San Antonio for 25 years before he retired. And he didn't come in with credentials saying, gee, every time I testify, coincidentally, I'm a defense witness. No. To start with, he was a state's witness when he was a pathologist, of course, because he worked for the state. But he could be called by either side. So obviously he was a state's witness a lot. But in private practice, he told you, I'm called by the state, I'm called by the defense. It's not equal, but it's, called by both sides a lot. I testify for both sides a lot. He's a guy, apparently, that both sides will come to court and give fair and honest expert opinion. And concerning this theory that Mr. Martinez has regarding where Danny put his hands up and then it came down, somehow he was doing this and then like this. Do you remember when Mr. Martinez, or I hope you do, when Mr. Martinez asked him about that, and Dr. DeMaio said, it's possible, but it's unlikely. It's pure speculation. That was his opinion. In other words, it's possible, but we're not here for the possible. We're here for these gentlemen to prove this gentleman guilty beyond a reasonable doubt. Not to prove that he possibly, that might have happened. He was very clear about the bullet through the body, the one that went through and ended up in the wall. He said that is not to be taken as good, honest evidence, because you can't count on that body bullet because of what the body does to it when it goes through. It hits the cartilage. It hits the sternum, the chest bone, interferes with the fifth rib, and and it's wobbly, it's no longer stable. And so his expert opinion was that you can't use that as a head-on as to what happened. He said the bullet in the body, that's the one that lets him give his opinion that Daniel was leaning forward at the time, the one that stayed in with its downward path. And that was his opinion. And I suggest to you it was a credible opinion and one that you could rely upon. I wonder, or I ask you to wonder, it's not my job, I ask you to wonder why it is that the state did not call their toxicologist, Norman Wade, in their case to prove that Daniel Rodriguez was high on meth. Well, we don't have an explanation, but it seems odd. They obviously, I guess, think it wasn't an important fact. But how could it not be? So we called Norman Wade, who works in, I guess, the offices with Dr. Johnson. In other words, he works for the state. Just like I said with Dr. DeMaio, when he was an ME, the other side could call him if they thought he had relevant evidence. And we thought that Norman Wade's evidence was relative, was important. And as to the methamphetamine that was in Mr. Rodriguez, Norman Wade said that he thought a therapeutic dose was 0.02 to 0.05. And I hope you recall that at the time I put that down like this. That's like therapeutic bottom, just assuming that methamphetamine is something that people should use, and I think the testimony is clear that it was drug abuse. So that's what Mr. Wade said was therapeutic. Then he told us that when he did his calculation, toxicology, it was 0.62. That's what he found. That is a long, long way from 0.02 to 0.05. Dr. DeMaio, with his years of training, with his years of being a medical examiner, a forensic pathologist, and the director of the San Antonio lab out there in Bexar County, Bexar with an X in it. I remember that. They spelled Bexar, B-A-X-E-R, yes. He told you that that level is a very high level. There is no question that Daniel Rodriguez was high. And when asked about how it would affect someone, he told you first that it counter-affects an OC spray. That it counteracts the effect of a taser, and it suppresses pain and fear. Well, that sounds logical, doesn't it? It sounds like what happened in this case. It sounds like an explanation for why Mr. Rodriguez acted like he did. It sounds like Dr. DeMaio knew what he was talking about. He said it causes aggressive behavior, paranoia, psychosis, and have people get assaulted. And he told you how it affects the brain and the heart, and how it can cause anatomical changes in the brain, and in fact ends up injuring even the nerve cells in the brain. So I thought, it seems to me that his evidence was evidence that came from somebody who had testified in many venues for the state and for the defense and gave some straight, honest answers to what was going on with Mr. Rodriguez when he was in there, in the trailer, in there with Rich Chrisman. And he didn't say this, because this is your job, to decide if Sergio Virgilio's testimony that I was able to talk Daniel down. Rich had jacked him up, and I came in and talked him down. I think Dr. DeMaio should leave you with the clear impression that that sort of an activity would be just not what was going to happen to somebody that was that high on that drug of abuse. You can look at the photographs and evidence and see what kind of drug use and make your own opinions that Mr. Rodriguez was on. I mean, his mother in the 911 tape speaks to it. Listen to that. You can see what he weighed at one point and what he weighed later. You can look at there's pictures of his mouth, and those are all in evidence, and make your own conclusions based upon the evidence that we have in this case. Let me talk to you about then it says you can't shoot a dog unless you have a legal reason. And Mr. Martinez, I suggest, left you with the ludicrous explanation that only a person that's with the SPCA can lawfully kill a dog. That if I have a pit bull coming at me and I don't have a right to kill it. I don't think that's a reasonable analysis of that statute. I think that a police officer that is being threatened by a pit bull to do what he did. So it seems, I suggest to you that would mean that Mr. Chrisman is not guilty of that charge. The aggravated assault statute, one part of it deals with the gun, so we don't have to worry about that. Mr. Chrisman had a gun. The other part is the one I draw your attention to. Intentionally put another in reasonable apprehension of immediate physical injury. Okay. I suggest to you there are at least, but clearly, 3 reasons why you should find Rich Chrisman not guilty of aggravated assault. The first is, Rich Chrisman told you very candidly and honestly what happened. And he said, I did not do that. Secondly, if you look at the language of the statute, intentionally put another person in reasonable apprehension of immediate physical injury, and you look at Sergio Virgilio's testimony, if that's what they'd like you to believe, on page 43, here's what he said to him, right after he says this gun to the head thing. And were you able to see Mr. Rodriguez's expressions? Answer, yes. Question, tell me about that. Answer, he looked shocked, his eyes were wide open. Question, and did he continue arguing, or what happened in the terms of his demeanor? For the first few seconds, no. But then he started to argue again. So, I think that's the second reason. Even he didn't feel he was in reasonable apprehension of immediate physical injury. But the other and third reason has to do with Rich's testimony and the issue of depth perception. Because if you're standing outside the doorway and you see what happened, by that I mean what Rich Chrisman told you he did, when he took out his gun and pointed it at the dog and said, "Get back," call you, and then did this muzzle thing like this to Danny and said, "Call your dog off," one might perceive it much differently and might relate what happened much differently if you're standing back and watching this. It's called depth of field, and I think we've all got a fair grasp of that. And I'd like to show you a demonstration of Mr. Gann's help. He used this dowel as a gun. And see if I can ask him to react as Rich Chrisman and I'll be Danny Rodriguez. You'll be outside the door. So if he is Rich Chrisman and I'm Daniel Rodriguez, you can't be outside the door because the door's over there. So I'm going to turn us around, and the door is now for this demonstration over there. All right, I'm Daniel Rodriguez. And Rich Chrisman, I suggest the testimony is, he had a hold of Daniel Rodriguez, and he brought his gun up to the dog, and he said to the dog, "Get back," and pointed the gun at the dog, and then did the muzzle sweep, and said to Danny Rodriguez, "Call out your dog." And as you see the weapon, and as you're standing back, the depth of field makes you perceive it differently. Those of you right in front saw it one way, those of you over there saw it a different way. But I think that it's a reasonable explanation of what Mr. Virgilio might see. And finally, let's talk about the bike and the final charge of second-degree murder. I'd like to put up Exhibits 364 and 365 before I bring the bike over here and talk to you about it. I got it. These were some pictures from Mr. Hicks' book where he showed us this gun and this stuff coming out. Forget the bullets, these other things that come out. They've been called gunshot residue, they've been called particles, and you've heard about how they come out, how fast they come out, and the damage they can cause. And then there was another picture in this exhibit, 365, which showed what happened when, at 6 inches away from a piece of metal, sheet metal, I believe, sheet rock, sorry. That was one sheet metal, sheet rock. This sheet rock, what can happen with this sort of stuff. I just wanted you to get an idea, apparently, from what these photographs show this kind of stuff is that we're looking for. Okay. Mr. Martinez told you that there was nothing on this bicycle. Okay? Well, number one, what he told you is not evidence. I'm going to tell you, in my judgment, there is, but that's not evidence either. But you'll have the bicycle, and you've heard what this stuff is, and you can take it and draw your own conclusions as to what is and isn't there. This is the bicycle, and this is the side that would be facing Rich Chrisman. So when you're in the jury room, if you look in this area here, you can see dots things that are not over here. And if you look here and here and other places on it, you can see marks, little pinprick holes. You can see stuff in this bicycle. Take a look. And you can see it. Take a look at the other side. And see that it doesn't seem to exist on this side. And I think you could reasonably conclude that Martinez was wrong. But you know, one thing's for sure. They've had that bicycle for almost 3 years. Next month will be 3 years. And all they had to do was run swabs on them and test those swabs and bring them in and say, hey, here it is or it isn't. I mean, this 3 years later, it's way too late now. They didn't do that. They want you to convict someone by bringing in a bicycle and say, hey, trust me, there isn't anything on this bicycle. But there is. What is it? Mr. Martinez, I have no idea what he's going to say when he gets up, because he gets the last word. He's going to say, it's the manufacturer's paint job. Well, that'll be his opinion. It won't be evident. And that's his job to prove that was a manufacturer's paint job. It was his job, and his job, Detective Porter, to swab this thing and find out whether there's any gunshot residue or not. Not ours. It's not our burden. There's a picture, there's several pictures of the bike as it came to rest. And there was a demonstration by Rich Chrisman and Pat Gann with the bike, and they did what they did. Now, Pat Gann wasn't there. I wasn't there. Martinez wasn't there. And no one is suggesting that what Pat Gann did was exactly what Danny Rodriguez did. No one. It was simply a demonstration of approximately what Danny Rodriguez did, and where Rich Chrisman was, and why he felt his back was against the wall, and why he felt that he had exhausted every other reasonable alternative that a police officer has at his disposal, and why he had no choice to do what he did. But the bicycle ends up with the back wheel, as it was backed out, with the back wheel up on the pot, laying up on a plant pot or a flower pot. So how would a bicycle being wheeled out calmly to go to one's dad, then if it's on the floor, and according to Sergio, it falls over and it lands up on this pot? How would that happen, logically? Or if it's held like this and it hits the floor and bounces on those rubber tires, it makes sense that that's how it might have ended up like that. Or is this another theory of Mr. Martinez's about Rich Chrisman and his helpers, that they moved it? Is that the explanation? Can a bike be a deadly weapon? Ron Bartel told you it could be. He said it could be. Sounds like somebody that ought to know. It's unqualified. Mr. Martinez told you, and I don't, as I'm sure you know, don't agree with many things with him, but he did tell you that a knife can be used as a steak knife or a chicken knife. And if you see somebody cutting, I think he said, Well, that's not a deadly weapon. But a knife, we all know, can be a deadly weapon. And I believe, I took down his words, he says, it depends how it's used. Yeah, I have to say I agree with that one. It depends on how somebody uses this. Do you honestly believe that if I was a very young man in my 20s, a long time ago, and I was jacked up on meth, and I picked this bike up, came over at Mr. Martinez, you honestly believe he would not be in fear? Really? This is that picture I was talking to you about. It's 39. There's the bike up on that part. How could a bike that's being brought by somebody lift that way, come up like that, and end up in that pot? Just being called and bailed out by someone. I ask you to take a look at that and come to your own reasonable conclusions. And so, when you read the second-degree instruction that the judge has given you, I suggest you cannot come to the conclusion that Mr. Chrisman acted without premeditation and intentionally caused the death of another person, or knowingly that his conduct would cause death or serious injury, cause the death of another person, without any logical reasons. Because part of the instructions deal with a police officer being justified in threatening or using physical force against another if in the making or attempting to make an arrest or detention or preventing an escape, doesn't apply, such officer uses or threatens to use physical force, and all the following exist. I would ask you to read those carefully and apply them in this case. And I would suggest that you would come to the conclusion that when Rich Chrisman was in there dealing with Dan Rodriguez, that he acted reasonably. Again, hindsight is such a blessing for us, but none of us get to do that. We've got to think about what happened when he was there trying to do what he was trained to do, his job in this very, very small space with this barking pit bull. He acted reasonably. Did he act as he was trained and taught to do? Was he justified in doing what he did? Because as the instructions say, if you think there's a real possibility, and I'm reading from the instruction, that he is not guilty, you must give him the benefit of the doubt and find him not guilty. That's what the judge has told you. This is a court of law, and as we know, there are rules. And we all have to follow the rules. And one of the rules is that, as I mentioned, that the state has the burden of proving their case beyond a reasonable doubt. And one of the things that the rule also allows is that during closing, the state makes their opening closing, which Mr. Martinez did yesterday and today. Or yesterday, sorry. And the defense then gets to make their closing, which I am doing right now, but they get the last word. So when I'm done here shortly in a few minutes, Mr. Martinez will get back up and get to rebut and tell you why he thinks that what I've told you isn't correct, doesn't make sense. I'm not sure what he'll say. I hope you'll remember I haven't used the word faith and haven't asked for your faith much, if at all. I hope you'll remember that, as I told you in my opening statement, we would show you evidence, and I hope you will remember that for 2 hours or so, I've shown you evidence, and I haven't asked for your trust. I've asked you to look at the evidence in this case. I've asked you to look at the inconsistency in the statements by Sergio Virgilio. But I can tell you that when I sit over there, I'm going to want to get back up here and say, Mr. Martinez, that's just, But I want to tell you, I don't get that chance. So when he's saying these things, don't wonder what I would say, because I'm not going to be able to tell you. Those are the rules, and that's how they will be enforced today, as they've been enforced as long as I've been a lawyer. But just know, I'd like to get back up here and say something. But I can't. Now, Mr. Martinez seems to tell you that this bow and arrow and the knife and the bullets and all these things are unimportant because Rich Chrisman didn't know about them. But we have never suggested that he did. We have never, ever suggested that all of those clearly deadly weapons, certainly bullets, if whatever that gun was that went in that holster, or those shotgun shells in that shotgun, wherever it was, and I don't mean it was in the trailer, but it wouldn't have mattered. The purpose of those is to show you, and the purpose of bringing Norman Wade in, to show you about the level of meth that Mr. Rodriguez was on, is to show you what the situation was in there and what could have happened if they just retreated and just run away. I mean, Mrs. Fernandez called and said, he's real violent, he's hurting my dog, I'm afraid he's going to hurt me. Well, those weapons were in that trailer to hurt her. They were there, and he was there. That's why they are important in this case. Sergio Verdillo and the state would ask you to shut that door and walk away and let Mrs. Fernandez come home with that jacked up person with those weapons in there, with the knife in his back pocket, the throwing knife that he had. They would have you believe, and Sergio Virgilio would have you believe, that's their job. That when you call them and I call them or anybody calls them and says, I'm afraid for my life, I fear for my life, to use her exact words. He's violent. I'm afraid he's going to come back and hurt me. They want you to believe that his job was to leave him there alone so his mother could come back to her home, their home, and he could hurt her. That's not their job. I suggest to you, we all know that. That's common sense. That's why those items were important. You were told about Exhibit 383. My finger's on it. You can look at it. It's in evidence. 383. And it shows what came up as the pace record for Daniel Rodriguez. That Officer Chrisman, when he was on his way over there, when he was doing his job, he was taught to do his job, to run somebody to see who they were going to come in contact with. Not to run him later to find out what was happening when it was too late. Not to have no concern about it, but to have then. And find out that this person had, Daniel Rodriguez, the person, the one on this one record, had a previous problem with drugs, drug paraphernalia, and weapons. So, I suggest to you that the actions of Mr. Chrisman were those of a reasonable police officer under a reasonable situation, and that Rich Chrisman was doing what he was trained to do and what we want him to do. Rich Chrisman do what he was paid to do, what he was trained to do. You know, in 9.5 years, Rich Chrisman never used his weapon in the line of duty. This is a good man.
Objection. And pardon me. Well, actually, that's on 15.
I suggest to you that the evidence is clear that this is what occurred, and that 9.5 years he never had to use his firearm in the line of duty until October 5th. I suggest that this is a man who did exactly what he was trained to do. And I suggest that this is a man who was left all alone in that trailer by himself. And I suggest that when you read the instructions and you're told about what weight you can put on certain witnesses and how you should treat them, that you'll find that you can reasonably believe that Officer Mitchell's testimony is credible and that there is reasonable doubt in this case. But you will come to the conclusion that Rich Chrisman is not guilty on these 3 counts, these 3 charges. I'm done. Mr. Martinez will talk to you. Judge will instruct you. You'll go back to the jury room. You'll pick a foreman, and you'll deliberate. And at some point, you will come to a conclusion, and you'll reach a verdict and a decision on this. When that's done, your job will be done. And you will go home, and you'll go back to your loved ones, and go back to your life that you had, and go on about your business. In this case, will be a memory to you. But in your life, it will be over. But for Rich Chrisman, your decision will be the rest of his life. And I leave it in your hands. Thank you very much.
Ladies and gentlemen, we'll take the afternoon break at this time. Please remember the admonition. Keep an open mind still. We'll see everybody at 2:45. Jurors are excused. Anything for the record for now, Mr. Martins? No, Your Honor. Mr. Martinez? I'll see you at 2:45.
Put that back for me.